Let's do it. All right. Welcome, welcome. Sort of my would say fake live introduction. It was pseudo live introduction, but we're getting there. Um, Excited for today. We are just about done with Novak, so that's kind of exciting. Novak decision. We still have, in the fact part, we still have to go quite a bit of a ways to go through on the actual decision there. No law out of the dog today. She broke a monitor and is in the car. So that's how that's going. It's 1,000% my fault and nobody else's. But as they often say, you can take the dog out of the barn, but you can't take the barn out of the dog. So that's how we're doing with that one. All right. First day of December, where I'm at right now. I assume it won't be tomorrow when you're listening to this. But happy holidays to everybody. I'm sure we'll have more opportunities from that. So wherever you're at and, however these things go for you, whether you feel it's tyranny or freedom, I hope these holidays are what you expect them to be. All right. So we're going to do, we are going to finish this up here. We've got a couple of paragraphs left to do. And I did want to talk just a little bit more about constructive discharge and why the investigation matters, okay? So there is a lot of comments that out there basically that say that the investigation itself is a sham. And it's not that I don't agree with you 1,000%. It's just that ordinarily under the law, both in the Seventh Circuit here, federally speaking, and in Wisconsin, you are sort of expected to wait out the investigation. Another way to put it is a judge is not going to say that they don't have the right to investigate you for anything. They might say afterwards that it was, bogus, but you're supposed to wait out the investigation. So there may be some reasons why you wouldn't do that. And so that's part of what what we're getting at in terms of what was her reasoning for doing that. I think the judge is very clear that it was a calculation that she made. Now, it's not clear to me why that would be saying that she made a calculation is somehow mutually exclusive for saying that a reasonable employee would have felt forced to resign. So that's part of it. I also think, and it's true that the fact that these charges are bogus in and of themselves lend weight and credence to the fact that, hey, this investigation is intolerable. But again, it's not in so much of, and that's part of, I think, the thinking that goes along with that is you should welcome, as annoying as it is, you should welcome the opportunity to clear your name. And somebody who runs away from that isn't really worthy of the court's protection. I think that's a lot of what's sort of behind that. So that all is true. Another factors that are going against that is this gross negligence there and these gross misconduct and how that can jump the progression, and it's clear that you can get terminated. It's also, I think, clear that most the evidence was that she was getting advice from her fellow wardens, the male wardens, saying that she needs to resign to protect her benefits. So all of that needs to be really clear. There's a couple of issues here, and the first one is sort of what are the facts, and does the basically on an appeal here, the judge is entitled to find the facts that they can find unless you can show that it's an abuse of discretion, meaning she wasn't picking a winner, she was creating something out of whole cloth, or sky is green, as somebody said. So keeping all that in, that's the facts. But then again, we're going to the law and the question of What's the standard for judging whether or not somebody was forced to get out? Okay, so again, there are straight up decisions saying you should wait till the end, the consequence, the end of the investigation. Now, the distinction there is you should wait till the end of the investigation. You get terminated, you can get reinstated. There's other ways to deal with that. There is not the clear. I don't think those cases encompass a situation in which you're likely to lose $300,000, and that's why I think it's so abusive for the judge to not have included that fact. I mean, she mentions it, but for her not to put in that dollar number is deliberate, and not just a question of I'm going to pick and choose what the sort of reality is. But that is a fact that's definitely necessary here to acknowledge and to say why that doesn't matter, and to just leave that out there, and others that are all basically to not have any fact or any statement in this. How many pages are we at? Like, oh my gosh, 19, so some 16, 17 pages of pretty dense single-spaced text here is we haven't had anything about why Novak would feel that she had a target on her back. We've got some alleged statements. That's about as much as we make. We don't see why a reasonable person would feel that that they would need to resign. And part of what I'm trying to say here is when you leave those facts out, any facts, for her to say, I mean, the law does not require, and this is what I'm trying to get at, the judge to put in every fact at all, okay? But when, again, she puts in 15 pages worth of facts, and at no point does she mention any of the key facts in support of the employee's claim, it's beyond troubling. Because it's just evidence, I would say, of a predetermined conclusion. And as we'll see in sort of the analysis, the lack of those countervailing facts there just sort of enable the judge to focus on one part of the decision, that is that she's on leave and getting paid. So it does, ultimately, the judge's decision is going to come down to she's on leave getting paid, so therefore there are no other circumstances that could possibly have caused a reasonable employee to resign. And I think that in itself is that's what the mistake is. That, I think, is how I disagree with Bruce's point, that it's just the fence, and that the investigation was a sham and known to be a sham. And it's not also just the facts that Judge DeLaO is purposely leaving out. It's really that there's the ability to make a reasoned decision about whether or not, and especially at a higher level here, if it wasn't for all of these other issues, this would be very difficult. This facts here that she's coming up with and excluding absolutely everything that's in favor of Novak. She doesn't even just minimize. It's just gone. It's omitted. And I think that's, again and again and again, what the problem is here. All right. 73. On June 29th of 2020, Novak's working conditions were not so intolerable that a reasonable person would have believed that Novak had no choice but to resign. Okay, how's that a fact? At the time that Novak resigned, Novak was on administrative leave, and being paid her full salary of $1,700 $107,000, whatever. I don't know why I can't read that number, but we're going to move on from that. And receiving employment benefits that she received while working. Okay. Now, the simple fact that she's getting paid is not dispositive, as we says. It means that doesn't really answer the question in any sense, and it certainly doesn't end the question. Because somebody who is being sexually harassed every day, who walks into work and somebody's grabbing their butt every day, and the judge, was clear that that is somebody who would be qualified for constructive discharge. She did that person could also be getting paid that much money, or more or less, and yet still be compelled to resign. So it's not the fact that you're making $107,000 that has anything to do with whether a reasonable person would be forced to resign, or whether or not you're on administrative leave. Right? The issue was whether or not a reasonable person would think that if they were facing gross negligence charges under the situation that they were, meaning that it was obviously concocted, when the wardens are telling her that she should resign because Carr's out to get her, when Carr's making statements to the public that she's out to get her, that she's clearly aware enough and is making statements that Petracek, Carr, and Novak need to withdraw themselves from the decision because they're making the decision, are all part of why she knows, and the fact that she's been involved not in being disciplined, but disciplining. And of course, the key fact of all is Jim Swatchett's testimony that where all these decisions are actually being made is up top. Not in here once. You do see that, not in this decision once. And I would say the decision of Jim Swatchett to testify was probably one of the biggest flips that I've ever had, where we got somebody from management to tell what was really going on. And the fact that he's not in there at all is really puts, what's the point of going to the Equal Rights Division if they're not even going to put that man in there? That's the question that we all have to ask ourselves. What do you think? All right. There are alternatives, but this is supposed to be available for this purpose. So let's focus on that. This is what their job is and what they're supposed to be doing here. Novak was expected to stay on paid administrative leave, and she waited to see if she would be found to have violated the work rule violations, if any discipline she might receive, or if she would be exonerated of any misconduct. When Novak retired, Novak made a calculated decision to protect the benefits that she had rather than risk losing her sick leave conversion benefits if her employment was terminated sometime in the future because of her conduct in connection with the investigation of April 16, 2020 inmate escape. Okay, so let's just start from backwards, okay? So sometime in the future, because of her conduct in connection with the investigation, or because of a sham. So if we just change that part of the sentence, Novak made a calculated decision to protect the benefits that she had rather than risk losing the sick leave conversion benefits if her employment was terminated sometime in the future because of a sham investigation. Does that make sense then? No. So the fact that the investigation was not a sham and that she could have been disciplined, that's a key finding that this judge has to make in order to make that sentence, right? Okay. If her employment was terminated sometime in the future. Okay, so let's read that one. Novak made a calculated decision to protect her benefits, even though all of her coworkers her peers told her to retire because of her conduct in connection with the investigation of the April 16th inmate escape. Okay? Now, does that make sense? No. How about to risk her benefits rather than, because Carr made statements that he wouldn't hesitate to terminate her sometime in the future because her conduct in connection with the investigation on April 16th. Does that make sense? See, all of these things are necessary to have this sentence, not just in the coherency of the sentence, but this really is the sentence itself that is the whole buildup, the reason, I think, for all the rest of this 17 pages proceeding. If she would have been found to have violated work rule violations, and what, if any, discipline she might receive. And it's not just that we don't all know what the answer to that is, it's that there's no discussion whatsoever of the fact that Carr made public statements. There's discussion earlier, but there's no discussion in here about what a reasonable person would think had Carr made those statements. That's the key thing there. Was expected to stay on paid administrative leave. So, we can go and get a few of these in here. Because I think that's who was expected her. The question isn't that she was expected to go put through all this. Right? And I totally grant you that that's normally the situation is, to put it another way. The courts find that a sham investigation in and of itself is not enough to provoke constructive discharge. Does that make more sense? Okay. I think I could have, if I had said that 3 minutes earlier, we would have been a little bit further on, but it's okay. So, but that, I think, gets us to where we need to be in terms of why there is more here than just the sham investigation. Okay, there's a lot more than just the sham investigation. So both Weber and Gusky made the decision to stay our heroes in the disciplinary process after they were found to have possibly violated work rules that came to light because of the April 16th inmate escape. Both Weber and Gusky remained on administrative leave, receiving their normal pay from the DOC while they waited for the results of the investigation and disciplinary process. On July 16th, both Weber and Gusky received separate letters from Carr terminating their respective employment with the DOC as a result of their conduct that came to light because of the April 16th, 2020 inmate escape at CCI. Okay, I don't know that helps her. That makes it seem pretty reasonable that Novak's actions then, doesn't it? Both Weber and Gusky appealed the termination of their respective employments. Both Weber and Gusky reached settlements with the DOC that allowed them to return to the work for DOC. Okay. Now that's intentionally misleading there because they returned to work the DOC at a much lower rate. We all saw Mr. Gusky crying. That 76 is not, I'm going to say intellectually honest. I don't believe it's dishonest, but I think it's withholding the key truth that she must be aware of. There's a key distinction, a very key distinction. And that's all, again, my opinion, as all this is. But here we are. Somebody writes down the words. We have opinions. All right. The decision to place Novak on administrative leave while she was investigated for possible misconduct because of her conduct in relation to escape was based on serious concerns that Novak's conduct may have led to the April escape and problems with the response to the escape. By whom? The department? By whom? I mean, seriously. Seriously. Is that ever identified in here? Who made the decision? Novak's sex was not a factor in the decision to place her on administrative leave and to investigate Novak for possible work rule violations because... What? I mean, you're going to have some support for that. That's the whole conclusion of the case, that there's no causation. So it's only... It only was based on the concerns about the serious concerns that Novak's conduct may have led to the escape. Wow. Wow. Shut up. That's what I hear there. Sit down and shut up. Wow. Wow. Novak was not subjected to intolerable working conditions that would cause a reasonable person to believe that Novak had no other alternative but to end her employment by retiring. Novak was not constructively discharged by the DOC. Novak voluntarily resigned her employment so she could retire to ensure that she did not lose sick leave conversion benefits if she was terminated by the DOC. All right, conclusions of law. The respondent is an employer. The complainant is an employee. The complainant has failed to prove by preponderance of the evidence the respondent violated WIFA by discriminating against the complainant in terms of conditions because of her sex. The complainant has failed to prove by a preponderance of the evidence that the respondent has violated WIFA by terminating the employment of the complainant because of complainant's sex. Okay? Based on the findings of fact and conclusions of law, the administrative law judge issues the following order. The complaint is dismissed with prejudice, dated Milwaukee, Wisconsin, yada, yada. Believe me, it's appealed. Here we are. All right, well, next we have the beautiful memorandum. This is what we have yet to digest, is the commentary on the facts. So that's what we're going to be doing soon. I appreciate you all sticking with us. Judicial. How about that? And we'll get out as we came in a little bit. Anybody who doesn't like this musical interludes here, I feel doesn't understand, let's say, could understand better much of the pathos and agony that goes into these, it may seem quotidian, but this is people's lives here. And that silence is something, you gotta have the repetition, you gotta have the space. Music is counting. Never forget that. Music is counting. Stick with us. We'll keep you informed. More gems like that coming up. Happy weekend, everybody.